Good morning to everyone in and around this courtroom. Madam Magistrate, would you please call the case?
Good morning, Your Honors. This is case IT-0992T. The prosecutor is Mladić.
Thank you, Madam Magistrate. One second, please. Yes, the chamber was informed that the parties, or at least you, Mr. Mladić, would like to make a short submission in relation to the quote of yesterday. The quote that was introduced in the following way. The quote of General Mladić to be found at page 39 of the English translation as the document is uploaded in e-court, which I had understood as page 39 in e-court, and not the physical page 39 of a document which was uploaded in e-court, but where it appears on a different e-court page. If there's anything you'd like to add, please do so.
Yes, Your Honor. Just to clarify the record, we're talking about Exhibit P 431. And indeed, the hard copy, page 39, is the 35th page in e-court. The page Your Honor had, the 39th page in e-court, is the 43rd page.
Yes.
We are referencing the 35th page in e-court and the reference to the forehead kissing the ground, which is a euphemism in Bosnia for being born. So our position is that the quote relates to anyone being born in the country must live together in the country. And I thank you for the opportunity to correct the record.
Just to avoid any misunderstanding, that's also the position of the prosecution, that bowing your forehead to the ground has got nothing to do with a religious ritual, but rather with being born on a certain territory.
Your Honor, I'm not able to say that.
Yes.
I'd want to consult with some of our experts
Yes.
about that. Thanks.
Then we'll hear from you if it's any, if it is to be understood in any different way. Then we have concluded yesterday the 98 bis submissions by the defense, which means that the prosecution has now an opportunity to make its submissions in relation to what is found in Rule 98 bis, that is that the chamber should acquit if there's no evidence to support the indictment. I leave it alone whether it's charges or count. Please proceed, Mr. Groh.
Thank you, Your Honors, and good morning. Your Honors, today the prosecution will respond to General Mladić's motion requesting that this chamber enter a judgment of acquittal on all counts of the indictment on the grounds that there is no evidence capable of supporting a conviction. General Mladić's motion must be denied in its entirety. The prosecution has tendered, and the chamber has admitted, the evidence of over 360 witnesses and approximately 5,200 exhibits. This corpus of evidence establishes clearly and unequivocally each of the crimes enumerated in the indictment, the role General Mladić played in those crimes, and his criminal liability for them. Before we review our evidence, it may be useful to first briefly set out our understanding of Mr. Mladić's submissions yesterday.
You're kindly asked to slow down for the interpretation. Thank you.
First, Mr. Mladić has requested that the chamber depart from the well-established legal test applied to a 98 bis motion. I will address that in a few moments. Second, the defense challenges the prosecution's proof with respect to the overarching joint criminal enterprise set out in the indictment. I will also address the chamber on this. It is our understanding of the defense motion that it makes a very limited challenge to counts 9 and 10 of the indictment related to Sarajevo. Ms. Bibles will address the chamber on this challenge to scheduled crime G1. The defense challenges specific allegations related to the municipality's component of the case, and including Schedule D, as well as some specific allegations and individual crimes listed in Schedules A and B. Mr. Traldi will address those arguments. Mr. McCloskey will address several challenges to the Srebrenica component of the case. The defense challenges prosecution proof with respect to crimes in which non-members of the VRS took part or played a primary part. Both Mr. Traldi and Mr. McCloskey will address those aspects of the argument. Ms. Bibles will address the chamber on challenges related to counts 1 and 2 of the indictment, the crime of genocide, and I will conclude our submissions by addressing the chamber on Mr. Ivetich's broad challenge to our proof establishing liability pursuant to 7.1 and 7.3 of the statute. The defense has made a submission that the prosecution will not address in its response. Defense raised a number of issues related to how the indictment was pled. Rule 72 applies to such applications, and in this case, the chamber has already received and already decided upon the defense Rule 72 application. Let me first address the jurisprudence. Mr. Ivetich spent a considerable amount of time during his submissions encouraging the chamber to abandon well-established jurisprudence governing the test to be applied to General Mladić's Rule 98 bis application. In sum, he suggests that the chamber should depart from this jurisprudence and examine the proof related to specific factual allegations and specific incidents, and where it finds proof lacking, dismiss that particular allegation from the indictment. The analysis and test that the trial chamber must apply has been recently restated by the appeals chamber in its 98 bis judgment in the Karadzic case. It summarized the test in paragraph 21 of its judgment, which I will now read. Quote, "The appeals chamber recalls that a judgment of acquittal shall only be entered pursuant to Rule 98 bis of the rules if there is no evidence capable of supporting a conviction. The test to be applied by the trial chamber is whether there is evidence, if accepted, upon which a reasonable trier of fact could be satisfied beyond reasonable doubt of the guilt of the accused on the particular charge in question. Pursuant to Rule 98 bis of the rules, a trial chamber is required to assume that the prosecution's evidence is entitled to credence unless incapable of belief, and to take the evidence at its highest. It cannot pick and choose among parts of that evidence in reaching its conclusion." Unquote. In the context of General Mladić's motion, the jurisprudence is clear that should the chamber find there is sufficient evidence which, if credited, could establish General Mladić's guilt beyond reasonable doubt for a particular count of the indictment, the motion must be denied with respect to that count. This standard has been applied consistently since the plenary of judges adopted the current version of Rule 98 bis in 2004. This test was applied in deciding the 98 bis motions made by Mrksić, Mladić, Milutinović and his co-accused, Perlić and his co-accused, Milan Lukic and his co-accused, and most recently in the Hadžić case. Should this chamber depart from this for the last 98 bis application before this tribunal? The simple answer is no. Mr. Mladić has set out no reason for this chamber to apply a different test. The prosecution has prepared its submissions today with the expectation that the chamber will apply this established standard. Should the chamber be inclined to adopt the standard proposed by Mr. Mladić, I submit that procedural fairness requires that we know that and be given an opportunity to prepare our submissions accordingly. Finally, I would conclude my introductory remarks by saying the defense submissions, for the most part, have focused on narrow aspects of individual counts, with the exception of their broad attack on evidence establishing Mladić's 7-1 and 7-3 liability, as well as genocide. Their submissions leave much of the prosecution's case uncontested with respect to individual counts. The defense, by tailoring its arguments to a legal standard that does not exist, has failed in many respects to demonstrate that there is a basis for granting the relief sought under Rule 98 bis. Yesterday at transcript 20768, the defense suggested that insufficient evidence had been adduced to support the charge that General Mladić shared or intended to further the common purpose of the overarching JCE. In fact, the evidence clearly demonstrates that between 12 May 1992 and 30 November 1995, General Mladić was a pivotal figure in the evolution and the execution of an overarching criminal plan. The aim of this plan, whose genesis was in October of 1991, was the forcible and permanent removal of Bosnian Muslims and Bosnian Croats from the Bosnian Serb claimed territory. Put simply, the aim was ethnic cleansing. This plan was to be achieved through the commission of the crimes including deportation, inhumane acts, murder, extermination, and persecutions as charged in counts 3 to 8. The campaign of persecutions would, in some municipalities, escalate to include the crime of genocide. Yesterday, the defense argued that the prosecution failed to establish Mladić's liability for genocide under JCE 3, conflating concepts of both intent and liability. Mr. Mladić once again urges the chamber to ignore what he himself called, quote, established case law before this tribunal, unquote, and reject JCE 3 convictions for specific intent crimes. As recently as January of this year, the Georgievich Appeals Chamber affirmed that an accused can be found criminally liable under the third category of joint criminal enterprise for specific intent crimes, provided that the crimes were reasonably foreseeable to the accused. When Mladić joined the overarching JCE to rid Bosnian Serb territories of non-Serbs, it was foreseeable to him that genocide was a possible consequence of implementation of the common plan. This common plan of the JCE was conceived of and implemented by the leading Bosnian Serb and Serbian political, military, and police figures. It was a plan that was overarching of 3 additional and related JCEs. The crimes committed pursuant to and in furtherance of these JCEs ultimately furthered this overarching plan. The terror created through the campaign of shelling and sniping in Sarajevo, counts 9 and 10, was used to exert pressure on the international community and the Bosnian government in order to achieve their demographic objectives. The taking of UN personnel hostage, count 11, was aimed at gaining leverage over the UN and NATO for the same purpose. The forcible transfer and murder operations in Srebrenica were the starkest, most audacious examples of this persecutory campaign. The most prominent participants in the overarching JCE and these other 3 related JCEs were President Karadzic, President of the Presidency and later the expanded presidency of the Republika Srpska, and the Supreme Commander of its armed forces, and General Mladić, the commander of the main staff of the Army of Republika Srpska. Though Mr. Mladić claimed that, quote, the mere position General Mladić held within the VRS cannot be used as primary evidence to infer his criminal responsibility, unquote, the prosecution has never relied on Mladić's formal role as its strongest evidence of his culpability. Mladić contributed to the common purpose of the overarching JCE primarily through his authority and his ability to engage the armed forces under his command in the commission of crimes. Mladić also oversaw the VRS's cooperation with other institutions linked to other members of the JCE and who were similarly engaged in furtherance of the overarching plan. These included the RS crisis staffs, war presidencies, and the Bosnian Serb police under the control of President Karadzic. For example, see the evidence of RM 97 and adjudicated facts 363 and 365, as well as 373 and 405. Through JCE liability, Mladić is responsible for such crimes committed by these entities, regardless of whether they were committed by forces directly subordinated to the VRS or other institutions linked to members of the JCE. This cooperation between JCE structures is shown by the patterns and the systematic nature of the crimes committed and some of the discussions held between JCE members, including meetings of the RS Presidency, the Supreme Command, and the RS Assembly. And I would refer to Renaud Toynen's expert report, P3029, which discusses such meetings in detail. The existence of this common plan and General Mladić's involvement in it is demonstrated by the patterns of the crimes committed during the takeover operations that began in April 1992, and the operations that followed General Mladić's appointment as commander of the VRS. Other indications of this plan include the 6 strategic objectives when considered in their context and the military directives, orders, and instructions issued pursuant to and in furtherance of these strategic objectives. The circumstances in which these strategic objectives were formulated and in which General Mladić was appointed can be understood from a number of entries in his military notebook, P352. These reflect discussions in the week before Mladić's appointment, discussions held with key JCE members, Mladić and Krajisnik. Together, these entries tell a story that places a persecutory campaign at the heart of the VRS's war objectives. On the 5th of May, 1992, Mladić recorded a discussion concerning the objectives of the planned VRS and the, quote, relationship towards non-Serbian inhabitants in the territory, unquote. That is P352, E-Court page 246. At this time, the relationship towards non-Serb inhabitants was characterized by expressions of leading JCE members in favor of ethnic separation. For example, during March 1992, both Mladić and Krajisnik made speeches at Bosnian Serb assembly sessions in which they advocated ethnic division and contemplated takeovers of Serb-claimed territory, in particular Zvornik. These are noted in the expert report of Robert Donja, P. 2001. A few weeks later, BBC journalist Martin Bell witnessed 20,000 Muslim refugees outside the town of Zvornik, following an attack by JCE member Željko Raznatović, aka Arkan. That's P832. In a 6th of May entry, Mladić noted that, quote, in Bratunac, 2 representatives of the SDS are killing all Muslims by slitting their throats, unquote. This is P352 at page 253. He also records Mladić stating, quote, it would be a disaster if we did not separate with them. That's P352 at page 257. In the context of these violent takeovers on the 7th of May, during a closed meeting of select people, the strategic objectives were set out by Krajisnik and noted down by Mladić in his notebook. Mladić was also present at this meeting. The first of these strategic objectives, as noted by Mladić in his notebook, states, quote, 1, to separate from the Croats and Muslims forever, unquote. That's page 262. Mladić and Krajisnik were looking for an accomplished military commander capable of carrying out the type of persecutory campaign that had already begun.
Mr. Goon, parts of what you're saying soon will be missing on the transcript because of your speed of speech.
Thank you, Rod. I'll slow down.
Could you perhaps restart from the quote of the first strategic objective, to separate from the Croats and Muslims forever, and then parts were missing already.
Okay. That quote, which was restated helpfully by Your Honors, that's found at page 262 of P352.
If you read the transcript of page 10, for me it is line 17, you see that part of the sentence you
Oh, I see. Yes, Your Honor.
spoke already missing. If you could restart from there.
Yes. The first of the strategic objectives noted down by Mladić states, quote, to separate from the Croats and Muslims forever, unquote. Mladić and Krajisnik were looking for an accomplished military commander capable of carrying out the type of persecutory campaign that they had already begun. Someone with a proven track record. Someone who would consolidate gains made since April 1992 and continue the process of seizing Serb-claimed territory. Mladić had demonstrated his credentials for such a task while a commander in the JNA 9th Corps in Croatia during the autumn of 1991. There, soldiers under his command committed crimes against non-Serbs in Serb-claimed territories. This pattern of seizing territory and forcibly removing civilians in areas in Croatia would be repeated in Bosnia. As observed in the Krajisnik testimony of Milan Babić, now an exhibit in this case, the expert report of Renaud Toynens. On the 12th of May, 1992, Mladić attended the 16th Assembly session. At the end of that session, the VRS was formally established and General Mladić was formally installed as the commander of the VRS main staff. At that session, President Karadzic outlined the 6 strategic objectives to the plenary, stating, quote, "The first such goal is separation from the other 2 national communities, separation of states," unquote. The remaining 5 objectives set out by the Bosnian Serb leadership identified their geographic aspirations, territory which had been or would be seized, dominated, and ethnically cleansed. These objectives were articulated in the context of an ongoing campaign of ethnic cleansing. Following their promulgation and Mladić's appointment as commander of the VRS, this campaign increased in its scope and its scale. It is this context and the widespread pattern and systematic nature of the related criminal operations that give the strategic objectives their criminal implications. Within days of his appointment,
There seems to be a problem with the transcript.
I think there's an indication that the computer has crashed, Your Honor.
We'll ask through Madam Registrar, but this is a matter that can be fixed. We were warned already earlier this morning that the system had problems and became very slow. Mr. Kroom, I do understand that the computer has to be restarted, and of course the substance is every minute of these proceedings is too important to miss anything on the record. Therefore, I suggest that we take a couple of minutes, because that's the expectation. It would last, and then resume in anything between 3 and 5 minutes from now.
We'll stand by, Your Honor.
We'll just suspend the hearing for a short while.
All rise. Vive le All rise. Vive lever. Please be seated.
Mr. Groom, if you're ready to continue, please do so.
Thank you, Your Honor. I was talking about what happened immediately after the promulgation of the 6 strategic objectives. And it was in this context that the widespread pattern and systematic nature of the related criminal operations that give the strategic objectives their criminal implications. Within days of his appointment, the VRS, under General Mladić's direction, began contributing to the implementation of the overarching criminal plan. The first charged crime, Schedule A 6.2, took place in Hamburine on the 23rd of May, 1992. And by mid-June, massacres had been perpetrated by his soldiers in 6 different municipalities. One way in which Karadzic and Mladić applied the forces under their command was by turning the strategic goals into operational directives. As P338 at page 159 indicates, this is the 1993 VRS Combat Readiness Report. This demonstrates that the strategic goals served as a, quote, general guideline, unquote, for the VRS. This evidence is directly contrary to Mr. Ivetich's submission yesterday that Mladić somehow disagreed with the strategic objectives. JCE members met to discuss the progress made in implementing the strategic objectives. Following such meetings, operational directives would be issued, implementing orders passed down the chain of command, and military operations carried out. Some of these operations included the commission of serious crimes. The meetings prior and the events following the issuance of Directives 4 and 7 are notable examples of the way in which the political goal of permanent ethnic separation became absorbed into regular army orders, which led to the commission of crimes. Yesterday, the defense argued that the evidence shows General Mladić did not share intent related to any common purpose that has been identified by the prosecution. This was at transcript page 20,772. The crimes committed in furtherance of the JCE were clearly intended by Mladić and his fellow JCE members. Throughout our submissions here today, we will be referring to evidence of this shared intent. The evidence establishes that General Mladić created, shaped, and led the VRS to perpetrate the crimes contemplated by the overarching JCE. The claims made yesterday by the defense that there was a frail connection between General Mladić and the acts for which he now stands trial is simply not credible. There is a very clear connection between General Mladić and the crimes committed in pursuant of the overarching JCE. Through skillful and effective use of command and control principles such as single command, subordination, inspection, he established a system through which his orders flowed efficiently down the chain of command and the information he needed rapidly back up. That gave him what expert General Dannett described as, quote, fingertip control, unquote, over the soldiers under his command. His full and active engagement with his troops in the field ensured that he was often present at the most critical events in the war. Such was his commitment that on occasion his forcefulness and precision would rise to the level of micromanaging particular campaigns. Lest there be any confusion, Mladić's fingertip control, his ability to engage his forces with precision, is as important to any assessment of his criminal liability under Article 7.1 of the statute as it is under Article 7.3. His ability to effectively command VRS soldiers and apply them in the commission of crimes was his primary contribution to the joint criminal enterprise as set out in paragraph 13 of the indictment. I would ask you to keep this in mind as we review the evidence of the crimes and how they were committed. As my colleagues will describe, he used this control to devastating effect in his efforts to conquer and cleanse Serb-claimed territory. I will now ask Mr. Traldi to respond to the defense arguments related to the municipalities.
Mr. Traldi, you may proceed.
Thank you, Mr. President, and good morning. General Mladić and the VRS, in cooperation with forces under the control of other JCE members, implemented the common criminal purpose Mr. Groom described in a brutally efficient, genocidal, and persecutory campaign throughout the Bosnian municipalities. That campaign is charged in counts 1 and 3 through 8 of the indictment. In addressing the defense arguments about these counts, I will start with the objectives of that campaign, turn to Mladić's role in implementing it, and finally deal with the campaign itself. It is necessary to understand this was a single campaign in which each crime contextualizes and explains each other crime. I will thus address the criminal nature of the campaign and not artificially segregate specific incidents. General Mladić himself described the Bosnian Serbs' territorial objectives and demonstrated that he fundamentally shared in the common criminal purpose of the JCE. You can see on what should be the next slide, C2, that these targeted areas spanned the length and width of Bosnia. In an interview, in evidence as P1975, General Mladić called for taking, quote, back the territory Muslims took during World War II, and as punishment, even more than that. and he called for achieving, quote, the unification of the Serbian lands from Knin through Banja Luka and Sarajevo to Belgrade. And if you look at the blue areas on the map, you can see what General Mladić meant. Knin is just to the west in Croatia, and then the blue areas extend through the Arc, the Posavina corridor, cover the entire eastern border regions, and include the areas of Sarajevo claimed by the Bosnian Serb leadership. These areas parallel the territory identified by strategic objectives 2 through 6. These were the territories which Bosnian Serb leaders told witness Oken they intended to make, quote, ethnically pure Serb, or as overwhelmingly Bosnian Serb as they could make it. And that's in P3103, page 23. I'd refer you also to P431, page 449. General Mladić knew that this was a massive undertaking. Slide C3 shows that he told the RS Assembly, quote, people and peoples are not pawns, nor are they keys in one's pocket that can be shifted from here to there. It is something easily said, but difficult to achieve. The way that the JCE members achieved what Mladić termed shifting people and peoples from here to there was an organized campaign of ethnic cleansing through coordinated military operations in municipality after municipality. Other crimes, including the destruction of cultural heritage sites and the large-scale detention of non-Serb civilians, were committed to facilitate this ethnic cleansing process. Slide C4 shows that General Mladić cogently expressed the JCE members' common purpose to the RS Assembly in 1994, describing their historic chance to create a, quote, all-Serbian state. All-Serbian didn't leave much room for the people who lived in Ahatovici or Brdo or Žepa. And you can see on slide C5 how similarly other Bosnian Serb authorities described their common purpose. The first quote is particularly instructive in showing how the permanent nature of the forcible removal of non-Serbs flowed directly from the Bosnian Serb leadership's policies. After Radovan Karadzic presented the strategic objectives, one assembly delegate, Miroslav Vjestica, rose and proudly noted that there were no more Muslims in Bosanska Krupa. Then he asked, quote, will they have a place to return to? And he answered, I think it is unlikely after our president told us the happy news that the right bank of the Una is the border. And for your reference, Your Honors, P3853, page 9, shows that in 1995, Krupa was 100% Serb.
Mr. So we have now reference to P431. The previous one, I think you said page 40. The previous reference to that exhibit, you said page 49, which I think appears in the transcript at this moment as P449.
I think I may have stammered a little, Your Honor, and so it may have been my fault.
Yes, but it's clear that you wanted to refer to page 49.
Yes, Your Honor, thank you.
Please proceed. Sorry to have interrupted you.
The emphasis on permanent separation, which Mladić recorded in his notebook on 5 May 1992, was an integral part of the campaign he was asked to implement. And as you see here, that emphasis lasted throughout the war. I'd refer you generally to exhibits P2798 and P3072 regarding how Mladić and the other JCE members redrew the demographic map of Bosnia. General Mladić had an integral role in redrawing that map. He immediately established command and unified Bosnian Serb forces. And as commander of the main staff, his orders drove the JCE forwards. Mladić continually received information about how those orders were being carried out. This information is reflected in the trial record in 4 primary ways. First, his own notebooks, in which he recorded many of his day-to-day meetings. Second, the daily combat reports he received regularly from subordinate VRS corps. Third, his participation in meetings with international observers. And fourth, records of other meetings he attended, including meetings of the Republika Srpska government and meetings with local civilian authorities and lower-level VRS officers. The record shows that the reports he received paralleled the testimony of many survivor witnesses. These reports describe different VRS brigades utilizing the same tactics, committing the same crimes, and achieving the same criminal end. That consistency is not a coincidence. It is the inevitable result of decisions made at the strategic level to separate the population through the commission of crimes. Slide C6 shows a selection of the reports General Mladić received on the implementation of the JCE. The defense asserted yesterday that Mladić did not know or have reason to know that crimes were being committed during this campaign. In fact, he was extensively informed about its criminal nature. His subordinate corps often reported on the removal of non-Serbs from Serb-claimed territories. Several of the reports shown on this slide in the first section coincide with large ethnic cleansing operations in late May and late July. Indeed, VRS officers sometimes complained that civilian authorities were not efficient enough in removing non-Serbs from their municipalities, reporting, for instance, that the civilian authorities were not, quote, sufficiently organized in implementing this model for removal of the enemy, or suggesting that they, quote, work much harder at this. And that's P3815 and P3714. Other reports in General Mladić's notebooks described the flight of non-Serbs from Bratunac, Foča, Kalinovic, Ključ, Zvornik, and Serb-claimed areas around Sarajevo. Reports to General Mladić described the detention of large numbers of non-Serbs, and reports to General Mladić described murders which were repeated throughout the VRS campaign in the municipalities. From municipality to municipality, witnesses told the same story of the patterns of destruction wrought by Bosnian Serb forces. Serb takeovers of power, attacks against defenseless people, or violence that continued long after the fighting had stopped. Destruction of Bosnian Muslims and Croats' towns and sacred places. Detention of civilians as well as fighters in camps in inhumane conditions. Organized expulsions to a few holdout enclaves. And large massacres from Prijedor in the west to Vlasenica in the east, Foča in the south, and everywhere in between. These repeated patterns of crimes by forces under JCE members' control are highly relevant to showing their common purpose. I will focus on two for the moment. First, the killings across these municipalities reached a massive scale. P2796 and 2797 identify by name nearly 2,000 of the victims of the massacres charged in Schedules A and B of the indictment. These massacres, of course, led up to the killing of thousands more Bosnian Muslim men and boys when Srebrenica fell in July of 1995. Second, the defense referred yesterday to the destruction of non-Serb cultural heritage sites. The only reasonable inference from the uniform destruction of these sites is that it was part of the JCE members' common purpose and their persecutory and genocidal campaign. Mr. Riedelmeyer testified at transcript page 17933, no mosque in the indictment municipalities survived the war undamaged. This removed the core of non-Serb communities and the clearest visual evidence of their existence. The pattern of these destructions shows the widespread and systematic nature of the attack on non-Serb communities. The defense asserted yesterday at transcript page 20743 that the chamber cannot review evidence about uncharged cultural heritage sites. This is incorrect. Those sites are also relevant to prove the widespread and systematic nature of this campaign. I'd refer your honors to paragraphs 746 and 766 of the Ptolemyr trial judgment regarding the relevance of these destructions to the perpetrator's mens rea. P4333, pages 89 and 90, reflects that the destruction of non-Serb sites was part of JCE members' policy. That's the evidence of Bosnian Serb official Predrag Radić. And it is clear from the evidence of one VRS soldier that the uniform destruction of mosques was part of the policy. When he was asked if there were 19 mosques in his municipality, he said there couldn't have been, because if there had been, he and the other soldiers would have destroyed 19 mosques. That's at transcript page 17298. I'd refer you also to witness Tachi's evidence, particularly at transcript page 2098. Several Bosnian Serb witnesses gave evidence which demonstrates how the destruction of mosques fit into the plan to permanently and forcibly remove non-Serbs. Your honors have received evidence from Milan Tupajic, RM15, RM16, and RM513 that the Serbs believed that if the mosques were destroyed, the Muslims would not return. And that's P3170, P2362, P1054, and transcript page 17388. The permanent change in the Bosnian landscape wrought by these destructions was precisely the point. As to the specific defense arguments about individual sites, there is evidence in the trial record to support each charged site. Much of this is in Mr. Riedelmeyer's evidence, particularly P2503, 2510, 2511, and 2514.
Mr. Trolley, may I ask you to look at the new transcript page? We started again after the break. Page 9, lines 19 and 20. The name of the witness is not recorded and the page number is not clear. Please, can you repeat so that we are able to find it?
It's witness Tachi, Your Honor, at transcript page 2098.
Thank you very much.
Thank you, Your Honor. While the defense attempts to impugn some of Mr. Riedelmeyer's sources, his conclusions are corroborated by pre- and post-damage photographs, witness evidence in this trial, and they are also corroborated in large part by facts adjudicated by the chamber. Looking at the municipalities the defense singled out yesterday, each site in Bijeljina is addressed in Mr. Riedelmeyer's written evidence. P1054, paragraphs 77 and 78, discusses the large-scale destruction of mosques in Bijeljina by VRS forces and the message it sent that non-Serbs should leave the area. P4163 shows that the destruction of mosques in Bijeljina continued in 1993. And the chamber has recognized the destruction of Bijeljina mosques in adjudicated fact 517. Each site in Pale is also addressed in Mr. Riedelmeyer's written evidence, and witness Crnčalo testified at transcript page 3238 that all the mosques in Pale were destroyed while it was under SDS control. And perhaps my speed was off, but it's witness Crnčalo and transcript page 3238. Finally, Mr. Riedelmeyer was unable to reach an expert conclusion that 2 of the 4 charged mosques in Klinovik were destroyed during the indictment period, as the defense pointed out. However, the chamber has received witness evidence and found adjudicated facts on the subject. Indeed, as Mr. Mladić pointed out, the prosecution redacted P2800 on the basis of those facts. This evidence satisfies the Rule 98 bis standard, even if the chamber were to consider each mosque separately. The defense also offered boilerplate challenges to a large number of Schedule A and B incidents in the span of a few sentences. To be fair to the other components, rather than go through each incident in detail, I will simply discuss the genocidal campaign and explain how those incidents fit into the implementation of the JCE members' common criminal purpose. We will provide...
Mr. Hardy, could
Mr.
I
President.
just ask you one question? You referred to a witness who testified in paragraph 77 and 78. It was, what was it, 45? Let me just have a look.
It's P1054, and it's
Yes,
the evidence
P1054.
under, it's evidence under seal, Mr. President.
Yes. You referred to paragraph 77 and 78. Now, if I understood Mr. Mladić well, it's not that he ignores the existence of this evidence, but the issue he raised is that it is the quality of that evidence. I think he said, when the witness explains how the mosques were destroyed, that this information was spoken about in Bielina. Or in paragraph 78, this was a clear signal to non-Serbs. And what he challenged is not the existence of that evidence, but is that the witness apparently does not explain why he had the opinion that this was a clear signal, whether that is opinion or whether that is a statement of facts. And similarly for the sources of his information in paragraph 77. So if you say, well, there's the evidence, then that seems not to respond to what Mr. Mladić brought to our attention yesterday, if I understood you well, Mr. Mladić. Mr. Mladić is nodding yes.
And I just make 2 brief responses, Mr.
Yes,
President.
please do.
First, that looking at the quality of that evidence is precisely the type of weighing exercise that is for final judgment rather than for the 98 bis stage of the proceedings. Second, you singled out the quality of the witness's evidence, that this was a clear signal to non-Serbs that they should leave. As I mentioned a moment ago, that's evidence that the chamber has also received from a number of other Bosnian Serb witnesses, and I'd suggest for corroboration and explanation that those references are more than sufficient to provide it.
You say it's not only this quote from this witness, but it is the broader picture which puts this into context. Is that how we have to understand?
I would say you've
Argument.
encapsulated it better than I have, Your Honor.
Well, let's not make it a competition. Please proceed.
I appreciate that.
But I'm also looking at the clock. We are far beyond the time we usually take a break. Perhaps I was a bit disturbed by the interruption we had halfway, although that was certainly less than the 15 minutes we are over time now. Since I have interrupted you anyhow, Mr. Trowley, would it be of any problem if we would take the break now, or would you finish a few sentences before we take the break?
I think, Mr. President, I was about to turn to a different topic, and so this would be a good time.
Okay, then we take a break, and in view of the fact that we went on a bit longer, perhaps we should take a slightly longer break, and we resume at 11:15.
All rise. Veuillez vous lever.